Employment, environment, and consumer laws and regulation in Nigeria. The business world is a confusing and oftentimes dangerous place. This explains why business laws and regulation are made to protect business stakeholders. Without business laws and regulation, consumers will be at the mercy of business owners, employees will be at the mercy of employers, and business owners will be at the mercy of their competitors and suppliers. And the environment will be at the mercy of humans. If you are running your own business or company, it is important to know and understand some of the protection provided by these laws and regulation in order to prevent any surprises or costly mistakes down the line. This article will set out basic employment, consumer, and environmental laws and regulation in Nigeria. Employment. The first principle of employment law is that no one should be held in slavery, servitude, or forced to perform forced or compulsory labor. Slavery is when someone owns a person like a piece of property. Servitude is similar to slavery. A person might live on another's premises, work for them, be unable to leave, but they don't own such person. Forced labor means getting a person to do a work that he or she is unwilling to do under the threat of punishment or compulsion. Section 34.2 of the Nigerian Constitution allows forced or compulsory labor in special circumstances such as where a competent national authority prescribes compulsory service for citizens. Another important principle is that workers have the right to associate with others, including the right to join trade unions. Business owners should note that membership of trade unions is voluntary, even for public servants. The implication is that workers need not be compelled to join any labor union or workers' association against their wishes. Letter of employment. Employers should ensure that they issue letters of employment to their workers within 3 months from the date of commencement of employment. The letter of employment should contain the following. First, the name of the employer and an undertaking where the employer is employed. 2. The name and address of the employee. 3. The date of engagement. 4. The nature of employment. 5. If the contract is for a fixed term, the date is expired. 6. The period of notice for termination. 7. The rates of wages and method of calculation. 8. The manner and periodicity of payment of wages. 9. Terms and conditions relating to hours of work, holidays and holiday pay, incapacity for work due to sickness or injury, including any provision for sick pay and etc. The letter of employment must be signed by the employer or his accredited agent. The implication of signature is that it binds the employer to the term except he or she can show that he didn't sign it, it was signed without his authority, or worse still, it was signed in error. It is important to note that where there are no clear terms in the letter of employment, or where the term of employment isn't in writing and the court cannot discern the true intention of the parties, it may imply terms that are customary or part of trade practices, or such terms that are imposed by states or implied by court. Contract of service, of contract for service. An employment may either be in the form of a contract of service or a contract for service. A contract of service is a long-standing employment with all the benefit of tenure. A contract for service doesn't make a person an employee. Where the contract is a contract of service, It must be disengaged by giving the appropriate notice. The notice to be issued shall be in this format by the provision of the law. 1. One day, where the contract has continued for 3 months or less. 2. One week, where the contract has continued for more than 3 months but less than 2 years. 3. 2 weeks, where the contract has continued for 2 years but less than 5 years. 4. 1 month, where the contract has continued for 5 years. A contract for service can be dispensed with without resort to prior notification or payment of salary in lieu. It is also important that employers disengage their employees after complying with due process. Where they fail to follow the express term of the contract or where, in the case of contract of service, they fail to give the appropriate notice, the court will hold that the employee remain in their employment and may award damages against them. It is also important that the letter of dismissal doesn't mention criminal misconduct or allege that the employee has committed grievous misconduct. Where such allegations are made, the employee must be given a right to fair hearing before the employee is sacked or dismissed. It is also important to bear in mind the requirement of occupation safety and social welfare and security. The labor law imposes responsibility on employers to make sure their work environment, including offices and factories, satisfy safety standards. Some of these standards are based on the International Labour Organization Convention (ILO). Nigeria is a signatory to the ILO convention and its many states. This means that entities and persons in Nigeria ought to abide by their stipulation. These stipulations include provision as to health and safety, working time and overtime minimum wage, and etc. It is important to note that some of these provisions may not apply strictly, although every employer of labor, whether a big or small business person, should know them. Environmental laws. With the increase in globalization and sustainability advocacy, nations of the world are becoming more committed to the collective governance of the environment. As a result, business owners, particularly those involved in manufacturing and other industrial activities that can impact on the environment, will be required to pay special attention to environmental regulation in the course of their operations. Two categories of environmental regulation include domestic laws and international treaties and conventions. Domestic laws include regulation enacted by national and municipal authorities, while international laws are laws, rules, or regulations that govern the relationship between nation states. They are further subdivided into hard and soft laws. Hard laws are legally binding either because nations have signed up to them or they have become customary. Soft laws are not so binding. Some basic domestic laws on environmental regulation in Nigeria are the National Environmental Standard Regulation and Enforcement Agency Establishment Act 2007 and the 33 regulations made by the Minister of Environment under Section 34 of the Act, the Environmental Impact Assessment Act. These laws set out the general principles, procedures, and method of environmental impact assessment in various sectors, the harmful waste. This law prohibits the carrying, depositing, and dumping of harmful waste on land and in territorial waters. The National Environmental Standard Regulation and Enforcement Agency, the major federal body responsible for protecting Nigeria's environment, is responsible for enforcing all environmental laws, regulations, guidelines, and standards. Thank you.